Chapter 6 Depository Bonds, Sec. 120 Scope. In many cases where money is deposited in a bank, the owner requires the bank to give bond, with surety, conditioned for the safekeeping of the money and for its prompt return on due and legal demand. Such bonds are known as depository bonds and are very frequently issued by surety companies. The purpose of this bond is to protect the depositor from a loss in case the bank should fail, that being the only way in which a proper demand for the money is likely to be refused, and the condition of the bond is broken and liability accrues as soon as the bank closes its doors. The great majority of these bonds are required for the protection of public money. In some cases, the depositories are provided for by law, and are designated by the constituted authority in the state, county or city, as the case may be, and are required by law to give bond. In other cases, officers having the custody of public money, and being responsible for its safekeeping, voluntarily require the banks in which they keep the money to give bond. These bonds are often made so as to protect both the officer and his surety, as their interests may appear. In some few cases however, particularly in times of financial stringency, private individuals, firms and corporations require the banks in which they keep their money to give depository bonds. In all such cases, the bank is named as principal, and the bond is limited to cover the funds of a particular person, corporation or body politic. Sec. 121. The underwriting of depository bonds. As we have seen, the condition of a depository bond is broken and liability of the surety accrues as soon as the bank closes its doors and declines to pay depositors. The chance of loss under such a bond depends upon the continued solvency of the bank, and the extent of the loss may be affected by the character of the particular contract or obligation, insofar as it may affect the extent of the surety's right to participate in the distribution of the bank's assets. The character or personality of a bank is made up of its financial condition and the character of its management, and these matters will first be considered. We will then take up the matter of the extent of the surety's right, under different conditions, to participate in the distribution of the assets. Sec. 122. Financial condition. The financial condition of a bank will depend upon what is shown by its own statement and the probability that that statement represents its true condition. A financial statement of a bank is simply a summary of the contents of its books and shows a balanced account made up of liabilities on the one side and assets on the other. The liabilities are made up of capital, surplus, deposits, borrowed money, and the like, and the assets consist of the corresponding amount of cash, or its equivalent, in the shape of investments or deposits in other banks. In analyzing a bank's statement with a view of determining its strength, the two things to be considered are, 1, whether the liabilities are in the proper relative amounts, and, 2, whether the assets are properly invested and are worth the amount for which they are carried. The relation between the several items of liabilities will first be considered. Sec. 123. Liability, capital and surplus. When a bank becomes insolvent and closes its doors, all its assets, including the money paid in as capital, will be used to pay the depositors, and, to that extent, the capital is a margin of safety. But a surety for a bank is concerned primarily with the question of whether the bank will continue in business so as to meet the demands of its depositors, and, inasmuch as a bank cannot continue in business without a surplus fund, it is apparent that that is the real margin of safety, the chance of insolvency being in inverse proportion to the size of the surplus. The capital and surplus are not, however, to be considered in the absolute, but only in their relation to the other liabilities. $25,000 will be an ample surplus for a bank with $50,000 of capital and $250,000 of deposits, but will be wholly insufficient for a bank with $500,000 of capital and $2 million of deposits. In the handling and investment of large sums of money by a bank, there are, of necessity, many chances of loss or depreciation of assets, the chance being in direct proportion to the amount to be cared for and invested, and unless the surplus is large enough to take care of a reasonable loss or depreciation, the bank is not a good risk. This is another way of saying that while a large line of deposits may be an evidence of the confidence of the public, and therefore a good sign, yet, if there is not a proportionate surplus, the increased deposits may really weaken the bank. It is not practicable to lay down a hard and fast rule as to the amount of capital and surplus a bank ought to have to be reckoned as safe, because other things are to be considered. They should, as we have seen, be figured on the basis of the amount of the deposits or on the total amount of the liabilities, and it is suggested that it is reasonable to require a bank to have a combined capital and surplus equal to 12 or 15% of its deposits, and a surplus alone equal to 4 or 5%. There may be cases where, by reason of compensating advantages in other directions, a smaller capital and surplus would be satisfactory. The amounts herein mentioned are intended to be merely suggestions for the average case. But we must bear in mind that, while an adequate surplus is essential, it is not the sole, or even the most important, consideration in the question of the safety of a bank. As we shall see, a bank may be in a weak, or even critical, condition and still have a large nominal surplus, and furthermore, it is not difficult, by a comparatively slight inflation of the assets, to show a fictitious surplus. Therefore, while an adequate surplus is necessary, yet a risk should not be accepted merely because the bank has a large surplus. Sec. 124. Deposits. We have just seen that the surplus of a bank ought to be increased in proportion as the deposits increase, and that it ought always to bear a certain relation to the deposits. It is not to be inferred, however, that a large line of deposits is an undesirable thing. On the contrary, it is most desirable, as it is an element of great strength. The deposits of a bank are the source of its earnings. Earnings or earning power means prosperity, and the prosperous banks rarely, if ever, fail. It has been found in practice that by far the largest percentage of failures is among the small banks, that is, banks with small deposits, and that the percentage of salvage received from them is smaller than from the larger banks. Indeed, the experience of the companies seems to indicate that, up to a certain point, the risk on a depository bond is in inverse proportion to the amount of the deposits. As a rule, a bank with deposits of less than $60,000 should not be accepted at all, as such a bank necessarily has a small margin of safety and furthermore is not likely to make enough to pay its legitimate expenses, such as rent, salaries, heat, light, etc., and may therefore be compelled to employ inferior men, occupy poor quarters and go backward instead of forward. A large line of deposits is not only a source of large earnings, but it is an evidence that the bank has the confidence of businessmen, which is always a good sign, as they may be assumed to be familiar with the character of the management. In this connection, it is important to note the effect of an increasing or of a decreasing line of deposits. A decrease of deposits is an evidence of the loss of the confidence of the public, which is so essential to the success of a bank, making the possibility of a run the more imminent, and it is likely to weaken the bank and lessen its ability to meet the demands of its depositors in the future. This is so, because in order for the bank to meet the withdrawals, it must have been necessary for it to use its best or most liquid assets, that is, the assets that were of unquestioned value and on which cash could be most easily realized. This necessarily increases the proportion of slow or poor assets remaining in the hands of the bank, and puts the bank in an abnormal condition, where its ability to get money to meet the further demands of its depositors is greatly weakened. Even a slight run would probably compel such a bank to close its doors. It is suggested therefore that where a bank's deposits have been decreasing, great caution must be exercised, and where the decrease has been substantial or continuous, the business should always be declined. And on the same principle, a bank whose deposits are continually increasing is a good risk. Indeed, as we have seen, a bank whose prosperity is evidenced by a large and increasing line of deposits is likely to be in a flourishing condition and perfectly safe for depositors. Sec. 125. Borrowed money. It is considered entirely proper for a bank, at certain seasons of the year, when its customers are in need of large amounts of money for crop moving or other legitimate purposes, to borrow a reasonable amount of money in order to meet their needs. But it is not considered legitimate banking to make a regular practice of doing business on borrowed capital, making a profit out of the difference between the rate at which the money can be loaned and that at which it can be borrowed. The money is usually borrowed on short time, and is often loaned on longer time, and there is always a possibility that, by reason of changed financial conditions, or for other reasons, the bank from which the money was borrowed may decline to renew the loan. It may be impossible to get the money elsewhere, and the borrowing bank, having loaned out the money, may not be able to get it back in time to repay the loan, and may thereby be forced to close its doors. It puts a bank at the mercy of the bank or banks from which the money is borrowed, and is a very dangerous practice. The National Banking Act permits a national bank to borrow an amount equal to its capital, and, as a rule, no bank, whatever may be the law in the particular state, ought to borrow more than that. And a bank with a small surplus, as compared with capital, ought not to borrow that much, although, on the other hand, it would probably be safe for a bank with a large surplus in proportion to capital to borrow more. Perhaps the better general rule would be to say that a bank ought not to borrow more than 1/2 its combined capital and surplus. However, the amount of borrowed money, at any particular time, is not necessarily the true test. It is equally as important to determine that the money is borrowed for the purpose of meeting a temporary demand of customers and that it is not a continuing practice. Banks should not be under bills payable, as borrowed money is generally designated, for longer than from 4 to 6 months of the year. It is therefore not enough to examine a single statement of a bank, but its statements for at least a year should be examined so as to determine its practice with respect to borrowing money. It is suggested that a bank which has bills payable and rediscounts for more than an amount equal to 1/2 the combined capital and surplus, on which is in the habit of being under bills payable for longer than 4 or 5 months of the year, is an undesirable risk. In this connection, attention is called to a method which some banks have of attempting to conceal the amount they have borrowed by carrying it as certificates of deposit. When they borrow money, instead of giving a note, as is the regular practice, they give a certificate of deposit, payable at the date of the maturity of the loan. If, therefore, a statement shows a large amount of certificates of deposit, it may be assumed, unless the contrary is shown, that this represents borrowed money. In the sworn statements, which banks in most of the states are required to make to the state banking department, it is generally necessary to state what, if any, certificates of deposit are for borrowed money, and if such statements are available, definite information can generally be obtained. Sec. 126. The assets. Having ascertained that the several liabilities are in the proper relative proportions, it is next in order to determine as far as possible, whether or not the assets are properly invested and worth the amount for which they are carried. It is well known that worthless paper is often carried as a good asset and that the assets are otherwise inflated, and just to the extent that the assets are inflated, the surplus, as shown by the statement, will be false. In other words, every dollar of false or fictitious value in the statement of assets will be reflected in the surplus. Where the surplus is small or near the danger line, it is important to note the item of furniture and fixtures, as this item is frequently inflated in order to create a surplus. In such cases, this item should be ignored and the surplus reduced accordingly. It is not practicable for a surety company to make a special examination of the affairs of the banks that apply for depository bonds, so there is no way to absolutely determine whether the assets are what they seem. About the only light that can be thrown on this subject is by an examination of the report of the last audit of the state or national bank examiner, and by a consideration of the reputation and standing of the officers insofar as it may affect the probability that they would knowingly inflate the statement of the assets. Having regard to the proper investment of the assets, there are 1 or 2 points which will be considered in some detail in the following sections. Sec. 127. Convertibility of assets into cash. It is not enough that the assets of a bank be safely invested. They must be so invested that they can be converted into cash in time to meet any probable demand of the depositors. The ever-present danger of unusual withdrawals should always be provided for. Many banks, otherwise perfectly good, have been compelled to close their doors because their assets were not such as could readily be converted into money. Real estate and mortgage loans are recognized as slow assets, that is to say, assets which cannot easily be converted into money. Savings banks generally have the right, in emergencies, to require their depositors to give 30 or 60 days notice of their intention to withdraw their deposits, so that it is not so necessary for such banks to have all their assets in a form to be immediately convertible into cash. and it is generally deemed prudent for such banks to keep as much as 50% of their deposits invested in real estate and mortgage loans. On the other hand, commercial banks are likely to be called on at any time by their depositors, and they must pay immediately or close their doors. Hence the importance of having a large percentage of quick assets. It is not generally considered prudent for such banks to invest more than 20% of their deposits in real estate and mortgage loans combined, and where a larger percentage is so invested, the risk should be declined. Sec. 128. Cash reserve. Just as a bank is not safe unless it has a fair portion of its deposits invested in quick assets, so is it not safe unless it has a fair amount of available cash. As we have seen, a bank must always be in a position to meet the probable demands of its depositors, and for that purpose, cash on hand or in other banks is necessary. National banks are required by law to carry 25% of their deposits in cash as a reserve, although they are permitted to deposit a part of this in reserve banks or central reserve bank in the larger cities. Many of the states also require the banks incorporated by them to carry a cash reserve, but other states do not. However, experience has shown that it is not safe for a bank to carry a smaller reserve than 15% of its deposits, and a bank which habitually or even occasionally permits its reserve to get below that amount is not a good risk. Sec. 129. Character of the management. Although the liabilities of a bank may seem to be in the proper relative proportion, and although the assets may seem to be properly invested, and worth the amount for which they are carried, yet the management of the bank may be such as to make it an undesirable risk. There are some banks which are ultra-conservative, making only high-grade investments and loans only on gilt-edged security, and making no loans to officers or employees, and none in excess of the limit prescribed by law. Such banks are, of course, the best risks. Other banks are managed by speculators, who, in order to build up the business of the bank, grant unwarranted accommodations to depositors, such as paying excessive rates of interest and making loans on doubtful security. Such banks often succeed in getting a large amount of deposits, but if these deposits have been bought with undue accommodations, the bank is likely eventually to come to grief. Still other banks are managed by dishonest men who are in the habit of making loans to themselves, or to firms or corporations in which they are largely interested, without requiring adequate collateral, and to the extent that the collateral is inadequate, the surplus of the bank is fictitious. As we have seen, it is not practicable to make an examination of the affairs of banks which apply for depository bonds for the purpose of determining the character of their loans and investments. However, the character of a bank in this respect is generally known, to a greater or less extent, in the community in which it operates, and it is not only important but also the duty of an agent of a surety company to make himself conversant with the local conditions in banking and business circles in order that he may act intelligently on applications for these bonds. I do not believe enough attention is paid to the investigation of the management of banks applying for depository bonds. This is very important, for, as we have seen, it is not difficult for a bank, by inflating its assets, to show sufficient surplus when it is practically insolvent. Indeed, nearly every bank that fails has an adequate nominal surplus. If the management of the bank is not such as to warrant the belief that its financial statement is dependable, the application should be declined. Sec. 130. The character of the contract. In general, having determined that the particular bank is in a sound condition and reasonably safe for ordinary depositors, it is next in order to consider how the liability of the surety will be affected by the particular obligation for which application has been made, and whether or not, under the circumstances, the surety is justified in taking the risk. The liability of the surety, as it may be affected by different conditions, will now be considered. Sec. 131. Liability, as affected by right to salvage. In practice, insolvent banks always have some money to distribute to their depositors, and a surety, who pays one of the depositors, is generally entitled to receive the depositor's distributive share. The amount of the surety's ultimate liability may therefore be materially affected by the extent of its right to share in this distribution. This matter is presented in three aspects. In the first place, the particular depositor, who is the obligee in the bond, may be a preferred creditor, and entitled to receive the entire amount of his deposit before anything is paid to ordinary depositors. In most of the states, such is the law with respect to deposits of the funds of the state itself, and in a few of the states, the same rule applies to funds of counties and cities. Where such is the law, it is fairly safe to assume that a surety on a bond covering such a deposit, being entitled, upon payment, to all the obligator's rights against the bank, will not sustain an ultimate loss, because practically all insolvent banks have enough to pay preferred depositors in full. It is, however, not necessarily good policy to issue these bonds indiscriminately, because, in the first place, the failure of the bank will, if the surety lives up to his obligation, mean an outlay, for several months perhaps, of the amount of the deposit, and, in the second place, it generally means the incurring of some expense. However, a comparatively small volume of such business will take care of the interest and expense, and, where the right to a preference is undoubted, a surety company can afford to be fairly liberal. In the second place, there is the case where the obligee in the bond is an ordinary depositor and entitled to share with other depositors in the distribution of the bank's assets. In that event, the surety will ordinarily receive the full dividend rate on the amount paid by him. But, in the third place, we have the case where the deposit exceeds the amount of the bond, or exceeds the amount of all valid and enforceable bonds covering it, and where the depositor, notwithstanding payment by the surety of the full amount of the bond, has a right to have the balance of his deposit fully repaid out of the bank's assets before the surety is entitled to anything. In cases of private contract, a surety company usually makes it a condition of its obligation that it shall be entitled to the dividends on the amount paid by it, whether the obligee shall have been fully reimbursed or not. But in cases where the bond is provided for by law, and where the condition of the bond is fixed by the statute, such a provision would probably be declared void by the courts and is not generally inserted. In such cases the surety is subjected to an extraordinary hazard in that he may be deprived of all or a part of the dividends to which he would ordinarily be entitled. The ultimate loss, in case the bank fails, is increased just in proportion as the amount of the deposit exceeds the amount of the bond, or exceeds the total amount of all valid and enforceable bonds and securities covering the deposit. It is therefore the duty of a surety underwriter to see, in such cases, that bonds and securities, equal to the largest amount likely to be on deposit at any one time are carried, and if they are not to be carried, the bonds should be written only for large banks which are in absolutely first-class condition. Sec. 132. Liability, as affected by the right to cancel the bond. In some of the cases where depository bonds are required by law, the statute makes provision by which the surety may terminate its liability by giving notice to the person authorized to withdraw the deposit. And in cases of private contract, where the bond is not given in pursuance of any statute, the bond itself usually contains a provision by which the surety may terminate the liability by giving notice to the obligee. It is not generally believed that the surety on a depository bond may terminate the liability in the absence of any law authorizing it, or in the absence of any valid provision in the bond, although there seems to be a contrary opinion. However, in the absence of a definite settlement of this question by the courts, it is suggested that it is not safe to assume that the right does exist. The right to cancel the bond by notice to the obligee is a most valuable right and materially reduces the real hazard involved, for, in many cases, a vigilant agent of a surety company will learn of the weakened condition of a bank, on which his company is carrying a depository liability, and of its probable failure, in time to cancel before the crash comes. And in time of financial stringency, which seem periodically to occur in this country, banks which would ordinarily be good, are sometimes unable to get money to meet the demands of their depositors and are compelled to close their doors. These bonds can be issued with much more liberality where it is known that, if a financial crisis does come, or if the guaranteed banks do grow weak, the bonds may be cancelled. Bonds which will continue in force for more than 1 year and which cannot be terminated at the will of the surety should be issued only for the comparatively few large banks which are in absolutely first-class condition and about which there is no question. Sec. 133. The amount of liability. Having ascertained that the bank in question is a reasonably safe institution and an acceptable risk, and that there is nothing in the particular obligation to make it unacceptable. It is next in order to determine the maximum amount of liability to be taken, for there must be a limit somewhere. We have seen that where a bank has deposits of less than $60,000, it is an undesirable risk. But if the deposits are in excess of $60,000, a liability in proportion to the size and strength of the bank may be taken. In determining the amount of liability that may be taken, it is necessary first to establish a basis upon which the amount is to be calculated. Some underwriters take the aggregate capital and surplus as the basis and fix 25% as the maximum amount of liability to be taken. As we have seen, however, the amount of the deposits is a very important factor in determining the probability that a bank will continue in business. Therefore other underwriters take the total of the capital, surplus and deposits as the basis, and fix 5% as the maximum liability. It is impossible to formulate a rule that will do for all surety companies, because large companies can afford to take a greater liability than small companies. But it is suggested that for a company with an underwriting capacity of $250,000 or over, it would be reasonably safe to take a total liability equal to 25% of the capital and surplus, or 5% of the capital, surplus and deposits. Whether the one or the other basis is used, smaller companies should, of course, take a smaller percentage in proportion to their size. And it is to be borne in mind that this percentage will be increased or decreased as the bank may seem in other respects to be strong or weak, and, in each case, all the possible elements of weakness and strength, as above outlined, should be taken into consideration in determining the amount of liability, as well as in determining whether or not the risk should be taken at all.